Well, I have not had the pleasure of meeting this young gentleman who arrives here from that good company, FH&P. Shawn Speirs joins me in studio this morning. It's the first time you and I have had a conversation, although you have spent some time in the company of Gord Vizzuti.
I have indeed, yeah.
All right. You've actually brought an interesting scenario, I guess, or conversational thought starter. Certainly we all are aware of how crazy the real estate market is right across this country.
Absolutely.
But at the coast, it's just it's insane, although they say that prices have dropped by about 23% over the last couple of weeks because of some of these changes that have been brought in. But even so, you rush out to buy a property, and you discover that there's a property that's available for sale, and you're interested. You've got the money, you've got the cash. There's only one thing you don't know about. There's a tenant that is already living in this property.
Exactly. And, it is such a hot market right now. You're right. And a lot of people, especially with investment properties that already have tenants in the house, are they're starting to sell those properties. So we're running into these issues more and more often. So there's a couple of things that you need to know. First thing, as you said, you want to find out if the property does indeed have a tenant in it.
It does.
It does.
How deeply can you probe to find out who's living in what you're thinking might become your property, and they might become your tenant?
Well, you can ask the seller any information that you want, and they have to tell you, everything to do with the property. If you're going to purchase it, they need to disclose not only who's in the property, but what the nature of that tenancy agreement is. Is it a fixed-term tenancy? Is it a month-to-month arrangement? How much rents are being paid? Mm-hmm. Have there been late payments in the past, et cetera, et cetera? These are all things that you are going to want to know. But the next thing that people often run into, especially in the Okanagan, they want to inhabit this house ultimately once they've purchased it. So how do you deal with a tenant when you're purchasing a property that you want to live in?
How do you perform a rental eviction?
It's essentially what it is. Yeah, it's essentially
right,
what it is. Now, there's a couple of quirky little things. First of all, as a purchaser, you don't have the rights to ask to evict a tenant. So if
this is my property and I'm taking possession of it and I don't want you here, here's your 30 days notice?
But you can't do that yet because you don't actually have an interest in the property until the closing date.
Got it.
Right? So what you ultimately have to do is ask the seller to provide notice to their tenant. That request has to be made in writing. And one of the problems we run into in this market is there's so many what we call short sales. So the turnover is happening in weeks, not months.
Right.
So the 2 months notice that you're required to give to your tenant is not going to be able to expire in the time frame that the purchasers are looking for. You have to give them the sellers have to give the tenants 2 months notice.
Okay, you got to give them notice. But what if vacancy rate in this market is 0.07%? We all are very aware. There are agencies that find accommodation for individuals that are challenged. That I've done interviews with agencies where they actually have put a mom and 2 kids in a trailer in a mobile home park, because that was as good as they could do and as good as they could find within the budget constraints. So what if you give notice and then at the end of the 2 months' notice, the individual says, I haven't been able to find a place to live yet?
Well, one thing that helps with that sting is another thing that you're required to do on top of providing 2 months' notice is you need to provide the equivalent of 1 month's rent as compensation for the eviction, because you're using the exemption. It's called the personal use exemption. You're going to be using the property yourself. So they get 2 months' notice plus the equivalent of 1 month's rent. That helps a bit with that sting.
Gives them the downstroke
Yeah.
For their deposit that they've got to make on the next place they're going to move into.
Yeah, but you're absolutely right that there's just not a lot of places to live in Kelowna, and it's a reality that a lot of property owners are facing, where tenants just can't find somewhere to go. So what happens if a tenant just says, "Look, I'm not moving"? And we have
that was my question.
Yeah.
I'm not moving.
Yeah, I'm not moving
Yet.
So all of this is governed by the Residential Tenancy Act, and the body that sort of administers the Residential Tenancy Act is the Residential Tenancy Branch. Now, landlords or tenants can bring a complaint to the Residential Tenancy Branch if there has been a contravention of the Act. So if a landlord has provided the adequate notice and they have provided the adequate compensation and the tenant still doesn't move, then you go to the Residential Tenancy Branch, you make a complaint, and things are escalated.
Okay. I'm a single mom. I have 3 kids. I need a 3-bedroom unit, one for me and one for 2 of the kids, and then a 3rd bedroom for the second of my children or the third of my children. I need a 3-bedroom unit. Every one of the 3-bedroom units that I have looked at is priced way beyond my ability to absorb it into my budget. I cannot. Do you literally toss single mom and 2 kids out on the street? Is that kind of power available to the new owner of the property?
Well, I mean, it's not sort of as cut and dry as
heavy-handed.
It's not as heavy-handed as people are just sort of punting people right, left, and center. But there are steps that can be taken to force somebody to leave a property.
Right.
I mean, if you didn't have those protections in place for a landlord, then theoretically you would never be able to remove a tenant from your house ever. So I guess the scenario or a possible scenario is, what if for whatever reason you've got 2 houses, one is rented out and one is not,
right,
and you lose your job and now you have nowhere to live and you have the same 2 kids and you're a single mom or a single dad. Is it fair for a tenant to be able to say, "Look, I can't find
the right
somewhere to
supersede
live"?
those of the owner?
Exactly.
Right.
So that's what the Residential Tenancy Act and branch are there for. They govern these disputes, and there are processes in place so that you can indeed remove somebody from your property if you need to.
Is the process long?
It can be.
So not only did you get your 2 months' notice, but you know full well after talking to someone like Clay that the process of getting before the landlord-tenant organization, before bringing your dispute before them, et cetera, generally takes about 6 months. So have I got a 6-month window or a breathing opportunity?
Well, I don't think it's generally that long.
Right.
They do a very good job.
Try to move quickly
at the tenancy branch. And I think that they are often a little bit swamped and a little bit overworked. But I think that it's reasonable to get in front of somebody at least within a couple of months. But some people are very good at prolonging the process, and they can ask for adjournments for any number of reasons. They can ask for things to be sort of pushed back. And they can hold off the tenancy branch for as long as they can, so that they can, continue to stay in the property.
Conversation with Shawn Speirs. He's with FH&P Lawyers. We're talking about properties that are available for purchase, and you buy it, but it is a tenanted property. We're dealing with the whole process of personal use and how do you take control or how do you take ownership of your property and use it for you. There's another wrinkle in this whole story that I'm quite fascinated by. It's called demolition. And when we come back, we're going to spend some time talking about demolition. Demolition, as Shawn Speirs indicated to me, is not considered personal use, and it represents a whole new set of wrinkles. So if you love the lot, if you're buying it for the dirt, if you're not buying it for the tenant, and you're not buying it for the building, and you're going to flatten that puppy and build something new and beautiful for you, you may have bitten off a little more than you can chew. We're going to be back in a moment. Tuesday morning, as always, in Law Talk, we spend a little time in conversation with various lawyers from FH&P. You find FH&P at 275 Lawrence Avenue, beautiful new building built by the Warman Group. Absolutely a beautiful, beautiful building. We have conversations with Jim Herperker and any other of the fine family of lawyers that are there. Today, our guest is Shawn Speirs, and we're talking about purchasing properties that already have a tenant in them. But, Shawn, the whole scenario, I guess, or the case that is wrapped around demolition represents a whole other look at this business. So I find a property that I like. I'm not interested in the house. Love the lot. Love the view. That's the only thing I want. I'm going to flatten this puppy the minute I take possession. You're telling me I got some challenges.
Yeah, there are a few. And I mean, it's something that we're seeing more often in Kelowna. People purchase properties with the intention of tearing down the house and building something new. A common mistake that sellers are making is attempting to provide a tenant with notice to vacate the residence under the grounds of personal use when the prospective purchaser is intending to demolish the property. Now, under the Residential Tenancy Act, demolition is not treated strictly as personal use, and as a result, does not fall under the same exemption.
Help me here for a second, because I do intend to use the dirt that house is sitting on for personal use. But you're saying that while I may have a vision on what I'm going to use the dirt for, it doesn't extend 3 inches off the ground into the structure that is sitting on that dirt?
Well, it's not. It's still personal use, but it's under a different exemption.
Okay.
And the rationale for this is with the regular personal use exemption, the purchaser is planning on moving into the property straight away once the closing date hits or once the possession date hits. As a result, it makes sense for them to be able to ask the seller to provide their tenant with notice.
Right.
This rationale doesn't work if you plan on demolishing the property, because you can't get your permits until you actually own the property. So it wouldn't make sense for you to ask a seller to evict a tenant if you don't even have your permits in place.
Wow.
To demolish your property. So how it ends up playing out is you can't provide notice until the purchaser actually owns the property. Once the purchaser owns the property, and once the purchaser has all of the permits in place in order to demolish the existing structure, then and only then can they provide the existing tenant with the 2 months notice.
Notice of eviction.
Exactly.
So we're trying to create hoops through which the new property owner has to leap, designed to do what? To protect the rental tenant, or designed to protect the seller? Like, whose interests are we trying to protect here? It seems like it's become quite bureaucratic, but I don't understand the sense of.
Well, I mean, it is and it isn't. I think the Residential Tenancy Act and the Residential Tenancy Branch are there to protect both the tenants as well as whoever owns that piece of property. There are a myriad of circumstances where tenants and landlords do, in fact, need those protections. If some of these exemptions weren't there, for example, if you could just say, yes, it's going to be personal use, and
here's your 2 months notice.
Here's your 2 months notice. Evict them, and then go ahead and rent it out again, but for double the price.
Right.
Then
which is going on right now. That's one of that I understand. I know that the market can. I'm renting this property, or the property that I'm about to purchase is rented for $750 a month. And I know easily that I can get $1,250 for this 2-bedroom house. And my sense is that you're stuck at $750. You have no room to go to $1,250. I'm going to punch your sorry behind out the front door as I bring the new guys in the back door that are going to pay the $1,250 a month.
Exactly, and that's why these protections are in place. And there are actually protections dealing specifically with rental increases in BC. Now, there's a couple different ways that a tenancy can be set up. It can be a month-to-month tenancy. It can be a fixed-term tenancy with consecutive fixed terms contemplated at the end of the tenancy.
And would that be 6 months to a year, or like?
It can be whatever is contemplated in the original lease agreement.
Okay, all right,
contract.
all right.
It can be for a fixed term, and then it turns into a month-to-month tenancy, or it can be a fixed term with a move-out clause that's triggered at the end of the tenancy. Now, in all of these circumstances, except for one, there is a rental increase limit that is imposed by the Residential Tenancy Act. The way it's calculated is the inflation rate plus 2%. So for 2016,
so that's the maximum. That's the maximum increase that I can. The guy's at $750 a month. I'm only allowed to increase or bump it up by 2%.
Well, inflation rate plus 2%.
Okay.
So 2016, it's 2.9%. For 2017, it's going to be 3.7%.
So that would give me 5.9 or 5.7 and 4.9%.
No, so those are the totals. So that's inflation plus the 2.
Oh.
Yeah, so it's not much.
That's pretty skinny.
It's pretty skinny. But one way that you can indeed increase it by however much you want is if you have a fixed-term tenancy with a move-out clause. The reason why this is if you've got the move-out clause in there.
Please define.
So a move-out clause is you have the house for 1 year, and at the end of the 1 year, you have to move out. It's as simple as that. If you have
so if you're happy being here for a year, it's yours, but just be advised on the 1st of September, I want to see the last of you.
Exactly. Now, what people are doing is they're putting those move-out clauses into their lease, but their intention isn't necessarily to make the tenant move out at the end of the year. What it does allow the landlord to do is change the rate of rental at the end of that 1 year by however much they want, because they no longer have an agreement. So if the tenant wants to stay on, then they have to create a completely fresh new agreement that is independent of the other one. If you've got an option to extend by another 6 months, or if you have the option to turn it into a month-to-month tenancy, then your rental increase rate restrictions are going to be imposed by the Residential Tenancy Act. So it's something that as a landlord you should know, and as a tenant you should know, because when you're looking at these leases, you need to know.
Read the small print.
Read the small print and figure out why things are set up in the way that they are set up.
If there's anything here that's a surprise to you, a couple of things surprising me. One, including that move-out clause that effectively can be structured so that you get a brand new agreement every year. And it allows pretty much the landlord, holus bolus, as much freedom as he wants to set what would be, in his mind, market values, market rates for the property that you are renting. 250-862-2525, 250-862-2525. If you have any questions, Shawn Speirs would be happy to answer them. He's a pretty good guy to know, it would seem, when it comes to buying tenanted properties. And how to exist and how to protect yourself if you're a tenant, how to protect yourself if you're about to become the new owner. We'll take a break. Back in a moment. Happen to like Tuesday mornings. They work for me. I have a chance to spend some time in the company with some of the lawyers from FH&P. Always take something new away with me, depending upon the conversation and depending upon the legal expert who's here. Right now, Shawn Speirs deals with real estate, and we're talking about tenanted real estate in particular. And let's go to the phones now. Jim, good morning. Say hello to Shawn Speirs.
Good morning, Shawn.
Morning, Jim. How are you?
Good, thanks. I'm going to run a scenario by you and just see what your thoughts are. We recently purchased a home that had a tenant in. There was a home and a carriage home, and there was a tenant in the carriage home, and the house was empty. Our realtor wrote into the contract vacant possession, even though that there was a tenant in place, and the seller said there won't be a problem getting the tenant out. So we'd asked, or the realtor asked for a copy after the subjects came off, a copy of the lease just to confirm that the tenant would be out. Well, as it turns out, the tenant was on a fixed-term lease till the end of December, and then it reverts to a month-to-month.
Yeah.
What recourse do you have to get the tenant out when the contract stipulates vacant tenancy?
Well, fixed terms are another one that can be a bit tricky. With a fixed term, you can't necessarily just give your sort of standard personal use exemption 2 months plus the compensation package. So you might be stuck with that tenant until December. I suppose there are a couple of avenues that you can look at.
You could also start fixing that hot rod in the driveway just outside their front door. you could start doing boat maintenance.
Well, that might run you into a couple of other issues with the tenancy branch.
Sorry, I just had to jump in.
So I think your main issue is going to be with the seller. You're going to be able to say that, look, you've warranted to me that we're going to have vacant possession, and when we look at some further disclosure, we see that this warranty that you've made to us was, in fact, incorrect.
Right.
Now, you can sort of look at a couple of things. You can ask for an adjustment to the purchase price. You can, of course, talk to the person that's in that property. Just because somebody has a fixed-term lease doesn't mean that you can't come to some satisfactory agreement just between the parties. Right. They might be more than willing to move out. The seller obviously thinks that there's not going to be an issue having them leave. Maybe they're right. So you should have that conversation with them. But I think that your recourse is probably going to be with the seller as opposed to with the tenant, because with those fixed term tenancies, like I say, they're much more difficult to provide that sort of 2 month notice.
So if the existing tenancy, if you take possession of the property in the middle of September and we're the new owners, at that time, I know it's 60 clear days for asking somebody to leave. Can we ask them to leave at the end of December, per se, or are we stuck with them? Because at the end of that lease, it goes to a month-to-month.
So what you could do is provide notice 2 months prior to December, right?
Okay.
And then they were given notice that the end of the fixed term is indeed going to be the end of the tenancy. That way, it never transitions into a month-to-month tenancy.
Okay.
Does that make sense?
Yeah, that makes sense. And also, what if the tenant who's in there now is not paying rent to the seller, and the seller is actually giving the tenant an eviction notice because he's not paying rent? So we're ending up with a tenant that's sort of like squatting. He's basically not paying.
You're ending up with the squatter. Yeah, I think that, first of all, you're going to hope that they're able to get them out prior to the closing date.
Right.
So you could put a little bit of pressure on the sellers, saying that, no, as a term of the contract, you want vacant possession and you want them gone prior to the closing date or prior to the possession date. Whether or not they're able to do that might be another story. But, there could be a holdback built in into the contract that contemplates this squatter. There could be, again, an adjustment to the purchase price. There are a number of ways that you can go about it, but it sounds to me like the process is already in place to have them removed. But if you do indeed go ahead, purchase the property, and inherit the squatter, then it can become your problem. So you should have some appropriate protections in place, whether in the form of a holdback or.
Does the seller have to agree to the holdback?
Well, they will have to agree to the holdback, but I think the issue is they've made a warranty to you
right.
that you're getting vacant possession and you're not.
Right.
The other thing you have to be aware of is the reality of the real estate market in Kelowna. and there are bidding wars on properties. Properties are getting snapped out the day that they're listed, etc. So buyers are put in an awkward position because they are on the sort of losing ground in terms of negotiation. You can start to flex your legal muscles, but in the event it collapses the deal, then they might just sort of say, you know what, I'm going to be able to sell this to somebody else tomorrow. So tough.
You're between a rock and a hard place here, Jimmy.
Yeah, it's not sounding too good. So recourse on this as well. I'm just wondering, Shawn, could you go ahead and at completion, if they haven't honored or fulfilled their part of the contract, could you sue them for breach of contract?
That it gets a little bit hairy. You'd have to look at the wording, like the precise wording of the contract, because it really will depend. The other thing is you are aware of some of these issues. So once you become aware of an issue, you have an obligation to mitigate your risk. So you can't just sort of sit on your hands, wait for the harm to happen, and then sue. So you're going to run into a couple of other problems. Whoever is doing your conveyance will be happy to have a chat with you and review that. They should be reviewing the contract anyways, and going over all of these issues with you. But yeah, you've got a couple of options, but there definitely is a rock and there definitely is a hard place behind you. So you should definitely get some advice.
Okay, I appreciate your time. Thanks, Shawn.
No problem.
Listen, I appreciate the phone call. So Shawn, as I listen to this scenario as set out by Jim, this party says this party says this, and then you suddenly find yourself in the middle of it, discovering really, the tenant hasn't been paying rent, the tenant has already received eviction notices, the tenant has flipped the bird to his existing landlord, and as Jim described him, he's effectively a squatter now. I don't think that's where I want to start in the possession of my real estate.
It might not be, but like I said, if it's your dream house, then it might be something you can deal with.
Yeah.
And, the residential tenancy branch is there for these types of issues. So it's just about how much risk can you tolerate and how much do you want
and how much anxiety
property.
And how much sleepless nights and how much tossing and turning and pounding your pillow do you want to go through?
Yeah, and it's a little bit different in Jim's situation because it sounds like at least there's a house and then there's a carriage house. So it's not like it would be preventing him from moving into the house, the prime residence. Yeah. It gets especially hairy when it's the only residence and you've got your squatter in there. But
at the same time, I now have taken possession of the house that I really want. The carriage house was a beautiful added bonus in the deal. My wife absolutely loves the idea of having her mother move in there. But in the meantime, we've got a squatter sitting there, and I've now inherited a huge problem, short of having bailiffs come and packing their stuff up and moving it out and putting it on the curb.
Yeah, well, I mean, I don't know if it's
I have a tendency to exaggerate and go off the other end. I recognize that I have a tendency, but to me, that's sort of how I see this thing playing out.
Well, I mean, it's not a huge problem. It's a hiccup. But hiccups can be dealt with.
That's why we have lawyers?
That's why we have lawyers. That's why we have the residential tenancy branch set up. And no problem is too big to solve. So.
All right. Shawn Speirs can be found at FH&P. The street address is 275 Lawrence Avenue, Suite 400. What I suggest you do is go online to FH&P Lawyers. And if you've got some challenges with a tenanted property, or if you're considering buying a property that would be tenanted on possession, sounds to me like Shawn Speirs may be somebody that you might want to be talking to. His direct line is 869-6039 at FH&P. Shawn Speirs, a pleasure to have you in the studio this morning.
Good to see you, Phil.
You come back in about a month, and now that I've got some sense of the area that you like to play in, your sandbox, if you will, I think over the next little while, the real estate market is going to continue to present all kinds of problems and challenges for people.
It sure is.
So come back and see us in about a month.
Sounds good, Phil. See you then.
Pleasure. Thank you. Shawn Speirs from FH&P on our Tuesday Morning Law Talk.